United Nations Conventions on International Bills of Exchange and International Promissory Notes. At Best Kept Secret 510, teaching history on the system.
United Nations Convention on International Bills of Exchange and International Promissory Notes. United Nations, New York, 1988. United Nations Convention on International Bills of Exchange and International Promissory Notes. Chapter I. Sphere of Application and Form Op TBE Instrument. Article 1. 1. This convention applies to an international bill of exchange when it contains the heading International Bill of Exchange UNCITRAL Convention and also contains in its text the words International Bill of Exchange IUN CITRAL Conventional. 2. This convention applies to an international promissory note when it contains the heading International Promissory Note UNCITRAL Convention and also contains in its text the words International Promissory Note UNCITRAL Convention. 3. This convention does not apply to checks. Article 2. Lat least situated. An international bill of exchange is a bill of exchange which specifies two of the following places and indicates that any 280 specified are in different states. Th. Place where the bill is drawn J1 approximately .1 th place indicated next to the signature of the drawer. £1 th place indicated next to the name of the drawee, at the place indicated next to the name of the payee J. The place of payment, provided that either the place where the bill is drawn or the place of payment is specified on the bill and that such place is situated in a contracting state. 2. An international promissory note is a promissory note which specifies at least 2 the following places and indicates that any two specified are situated in different states. Th place where the note is L the place indicated next to the signature of the maker £1 the place indicated next to the name of the payee. The place of payment, provided that the place of payment is specified on the note and that such place is situated in a contracting state. 3. This convention does not deal ith the question of sanctions that may be imposed under national law in cases here and in court or false statement has been made on an instrument in respect of a place referred to in paragraph 1 or 2 of this article. However, any such sanctions shall not affect the validity of the instrument or the application of this convention. Article 3. 1. A bill of exchange is a written instrument which contains an unconditional order whereby the drawer directs the drawee to pay a definite sum of money to the payee or to his order T. Is payable on demand or at definite time. £1 1 Is dated J. II signed the drawer. 2. A promissory note is a written instrument which definite contains an unconditional promise whereby sum of money to the payee or to his order the maker undertakes to pay a is payable on demand or at a definite time. £1 is dated is signed by the maker. Chapter 11. Interpretation Section 1. General Provisions. Article 4. In the interpretation of this convention, regard is to be had to its international character and to the need to promote uniformity in its application and the observance of good faith in international transactions. 3. Article 5. In this convention JAS 111A. Ands an international bill of exchange governed by this convention. Note means an international promissory note governed by this convention. Instrument R means a bill or a note. Drawee R means a person on whom a bill is drawn and who has not accepted it. Payer means a person in whose favor the drawer directs payment to be made or to whom the maker promises to payj. Holder R means a person in possession of an instrument in accordance with Article 15. Protected holdic R means a holder who meets the requirements of Article 29. High guarantor means any person who undertakes an obligation of guarantee under Article 46. Whether governed by paragraph 4 guaranteed or paragraph 4 of Article 4 feet. W acceptor. Party means a person who has signed an instrument as drawer, maker, endorser or guarantor. 1. Maturity means the time of payment referred to in paragraphs 4, 5, 6 and 1 of Article 9. K. Signature means a handwritten signature, its facsimile or an equivalent authentication effected by any other means. J. Forged signature includes a signature by the wrongful use of such means. J. 1. Money or currency includes a monetary unit of account which is established by an intergovernmental institution. R. By agreement between two or more states, provided that this convention shall apply without prejudice to the rules of TTL intergovernmental institution or to the stipulations of the agreement. Article 6. For the purposes of this convention, a person is considered to have knowledge of a fact if he has actual knowledge of that fact or could not have been unaware of its existence. 4. Section 2. Interpretation of formal requirements. Article 7. The sum payable by an instrument is deemed to be a definite sum although the instrument states that it is to be paid with interest. 8y installments at successive dates. £8y installments at successive dates with a stipulation in the instrument that upon default in payment of any installment the unpaid ance becomes due. According to a rate of exchange indicated in the instrument are to be determined as directed by the instrument, or I. In a currency other than the currency in which the sum is expressed in. The instrument. Article 8. 1. Expressed words. If there is a discrepancy between the sum expressed in words and the sum in figures, the sum payable by the instrument ls the sum expressed in. 2. If the sum is expressed more than once discrepancy, the sum payable is the smaller sum, is expressed more than once in 9 years only, and in words, and there is a the SA-E rule applies if there is a discrepancy. The bum. 3. If the sum is expressed in a currency having 9 the same description as that of at least one other state than the state where payment is to be made, as indicated in the instrument, and the specified currency is not identified as the currency of any particular state, the currency is to be considered as the currency of the state where payment is to be made. 4. If an instrument states that the sum is to be paid with interest, without specifying the date from which interest is to run, interest runs from T-E date of the instrument. S. A stipulation stating that the sum is to be paid with interest is deemed not to have been written on the instrument unless it indicates the rate at which interest is to be paid. 6. A rate at which interest is to be paid may be expressed either as a definite rate or as a variable rate. For a variable rate to qualify for this purpose, it must vary in relation to one or more reference rates of interest in accordance W1-N provisions stipulated in the instrument, and each such reference rate must be published or otherwise available to the public and not be subject, directly or indirectly, to unilateral determination by a person who is N.E.4 in the instrument at the time the bill is drawn or the note is made, unless the person I. named only in the reference rate provisions. 7. If the rate at which interest is to be paid is expressed a variable rate, it may be stipulated expressly in the instrument that such rate shall not be less than or exceed a specified rate of interest, or that the variations are otherwise limited. 8. If a variable rate does not qualify under paragraph 6 of this article or for any reason it is not possible to determine the numerical value of the variable rate for any period, interest shall be payable for the relevant period at the rate calculated in accordance with paragraph 2 of Article 70. Article 9. 1. An instrument is deemed to be payable on demand. Or if it states that it is payable at sight contains words of similar import, or on demand or on pre-entente. If no time of payment is expressed. 2. An instrument payable at a definite time which is accepted or endorsed or guaranteed after maturity is an instrument payable on demand as regards the acceptor, the endorser or the guarantor. 3. An instrument is deemed to be payable at a definite time if it states that it is payable on a stated date or at a fixed period after a stated date or at a fixed period after the date of the instrument. At a fixed period after sight, £1 by installments at successive dates, or that by installments at successive dates with the stipulation default in payment of any installment the unpaid balance in the instrument becomes due. 4. The time of payment of an instrument payable at a fixed period after date is determined by reference to the date of the instrument. S. The time of payment of a bill payable at a fixed per lot after cite LS determined by the date of acceptancer. If the bill is dishonored by non-acceptance, by the date of protester, if protest is dispensed with, by the date of dishonor. 6. The time of payment of an instrument payable on demand is the date on which the instrument is presented for payment. 7. The time of payment of a note payable at a fixed period after cite is determined by the date of the visa signed by the maker on the note or, if his visa is refused, by the date of presentment. 8. If an instrument is drawn, or made, payable 1 or more months after a stated date or after the date of the instrument or after cite, the instrument is payable on the corresponding date of the month when payment must be made. If there is no corresponding date, the instrument is payable on the last day of that month. Article La-1. A bill may be drawn, by 2 or more drawers, less than payable to 2 or more payees. 2. A note may be made, L, by 2 or more makers, less than G payable to 2 or more payees. 3. If an instrument is payable to 2 or more payees in the alternative, it is payable to any one of them and any one of them in possession of the instrument may exercise the rights of a holder. In any other case the instrument is payable to all of them and the rights of a holder may be exercised only by all of them. Article 11. A bill may be drawn by the drawer. On himself, L payable to his order. Section 3. Completion of an incomplete instrument. Article 12. 1. An incomplete instrument which satisfies the requirements set out in paragraph 1 of Article 1 and bears the signature of the drawer or the acceptance of the drawee, or which satisfies the requirements set out in paragraph 2 of Article 1 and paragraph 2 of Article 3, but which lacks other elements pertaining to 1. 7. Or more of the requirements set out in Articles 2 and 3, YBCAAPL.TED, and the instrument so completed is effective as a bill or a note. 2. If such an instrument 18 completed without authority or other WI, then in accordance with the authority given. A party who signed the instrument before the Apletlon. Why invoke och lack of authority as a defense against a holder who had knowledge of such lack of authority when he became a holder L. According. A party who signed the instrument after the completion to the terms of the instrument so completed. Chapter Ill. Transfer. Article 13. Is liable. An instrument is transferred endorsee 8y endorsement and delivery of the enatru.ent by th. Endor to the pound by mere delivery of the instrument if the last endor, nt is in blank. Article 14. 1. An endorsement must be written on the instrument or on a slip affixed thereto, allonge I. It must be signed. 2. An endorsement may be, in blank, that is by a signature alone or by a signature accompanied by a statement to the effect that the instrument is payable to a person in possession it. Special, whom that is, by a instrument is signature payable, accompanied by an indication of the 3. If placed to seek nature alone, on the back of the other than that of the to we, is an endorsement only. Instrument. 8. Article 15. 1. A person is a holder if he is the payee in possession of the instrumental or pound, in possession of an instrument which has been endorsed to him, or on which the last endorsement is in blank, and on which there appears an uninterrupted series of endorsements, even if any endorsement was forged or was signed by an agent without authority. 2. If an endorsement in blank is followed by another endorsement, the person who signed this last endorsement is deemed to be an endorsee by the endorsement in blank. 3. A person is not prevented from being a holder by the fact that the instrument was obtained by him or any previous holder under circumstances, including incapacity or fraud, duress or mistake of any kind, that would give rise to a claim to, or a defense against liability on, the instrument. Article 16. The holder of an instrument on which the last endorsement is in blank AAYL. Further endorse it either by an endorsement in blank or by a special Endorsement. Pound. Convert the blank endorsement into a special endorsement by indicating in the endorsement that the instrument is payable to himself or to some other specified person, or less than £1 transfer the instrument in accordance with subparagraph pound of Article 13. Article 17. 1. If the drawer or the maker has inserted in the instrument such words as not negotiable, not transferable, not to order, pay XL only, or words of similar import, the instrument may not be transferred except for purposes of collection, and any endorsement (t), even if it does not contain words authorizing the endorsee to collect the instrument, is deemed to be an endorsement for collection. 2. If an endorsement contains the words not negotiable, not transferable, not to order, pay X only, or words of similar import, the instrument may not be transferred further except for purposes of collection, and any subsequent endorsement, even if it does not contain words authorizing the endorsee to collect the instrument, is deemed to be an endorsement for collection. 9. Article 18. 1. An endorsement must be unconditional. 2. A conditional endorsement transfers the instrument whether or not the condition is fulfilled. The condition is ineffective as to those parties and transferees who are subsequent to the endorsee. Article 19. An endorsement in respect of a part of the sum due under the instrument one's ineffective as an endorsement. Article 20. If there are two or more endorsements, it is presumed, unless the contrary is proved, that each endorsement was made in the order in which it appears on the instrument. Article 21. 1. If an endorsement contains the words for collection, for deposit, value in collection, by procuration, pay any bank, or words of seal 1 court authorizing the endorsee to collect the instrument, the endorsee i.e. a holder who may exercise all rights arising out of the instrument, may endorse the instrument only for purposes of collection, is subject only to the claims and defenses which may be set up against the endorser. 2. The endorser for collection is not liable on the instrument to any subsequent holder. Article 22. 1. Pledge. If an endorsement contains the words value in security, value in, or any other words indicating a pledge, the endorsee is a holder who may exercise all rights arising out of the instrument, may endorse the instrument only for purposes of collection. C is subject only to the claims and defenses specified in Article 28 or Article 30. 10. 2. If such an endorsee endorses for collection, he is not liable on the instru.ent to any subsequent holder. Article 23. The holder of an instrument may transfer it to a prior party or to the drawee in accordance with Article 13, however, if the transferee has previously been a holder of the instru.ent, no endorsement is required, and any endorsement which would prevent him from qualifying as a holder may be struck out. Article 24. An instrument may be transferred in accordance with Article 13 after maturity, except by the drawee, the acceptor or the maker. Article 2s. 1. If an endorsement is forged, the person whose endorsement is forged, or a party who signed the instrument before the forgery, has the right to recover ca pensation fat any damage that he may have suffered because of the fatgati against the person to whom the instrument was directly transferred by the forger. Cs. A party or the drawee who paid the instrument through one or more endorses for collection. To the forger directly or to Huver, an endorsee for collection is not liable under paragraph 1 of this article if he is without knowledge of the forgery. At the time he pays the principal or advises him of the receipt of payment, or at the time he receives payment, if this is later, unless his lack of knowledge is due to his failure to act in good faith or to exercise reasonable care. 3. Furthermore, a party or the drawee who pays an instrument ig not liable under paragraph 1 of this article if, at the time he pays the instrument, he is without knowledge of the forgery, unless his lack of knowledge is due to his failure to act in good faith or to exercise reasonable care. Less than. Of this except as Article UY against the forger, the damages recoverable under paragraph 1 not exceed the amount referred to in Article 70 or Article 71. 11. Article 26. 1. If an endorsement is made by an agent without authority or power to bind his principal in the matter, the principal, or a party who signed the instrument before such endorsement, has the right to recover compensation or any damage that he may have suffered because ot such endorsement against. The agent. The person to whom the instrument was directly transferred by the agent, a party or the drawee who paid the instrument through one or more endorses for collection. To the agent directly or to. However, an endorsee for collection is not liable under paragraph I of this article if he is without knowledge that the endorsement does not bind the principal. At the time he pays the principal or advises him of the receipt of payment, or at the time he receives paymentary 1 t I ater, unless his lack of knowledge is due to his failure to act in good faith or to exercise reasonable care. 3. Furthermore, a party or the drawee who pays an instrument is not liable under paragraph 1 of this article if, at the time he pays the instrument, he is without knowledge that the endorsement does not bind the principal, unless his lack of knowledge is due to his failure to act in good faith or to exercise reasonable care. 4. Except as against the agent, the damages recoverable under paragraph 1 of this article may not exceed the amount referred to in Article 70 or Article 71. Chapter IV Rights and Liabilities. Section 1. The rights of a holder and of a protected holder. Article 27. 1. The holder of an instrument has all the rights conferred on him by this convention against the parties to the instrument. 2. The holder may transfer the instrument in accordance with Article 13. 12. Article 28. 1. A party may set up against a holder who is not a protected holders. Any defense that may be set up against a protected holder in accordance with paragraph 1 of Article 30 Any defense based on the underlying transaction between himself and the drawer or between himself and his transferee, but only if the holder took the instrument with knowledge of such defense or if he obtained the instrument by fraud or theft or participated at any time in a fraud or theft concerning itj. A party, or if he fraud or any defense arising from the circumstances as a result of which became but only if the holder took the instrument with knowledge of such defense obtained the instrument by fraud or theft or participated at any in theft concerning itj any defense which I be raised against an action in contract between himself and the holder j. Any other defense available under e invention. 2. The rights to an instrument of a holder who is not a protected holder are subject to any valid claim to the instrument on the part of any person, but only if he took the instrument with knowledge of such claim or if he obtained the instrument by fraud or theft or participated at any time in a fraud or theft concerning it. 3. A holder who takes an instrument after the expiration of the liat for presentment for payment is subject to any claim to, or defense against liability on, the instrument to which his transferor is subject. 4. Protected a party may not holder the fact raised as a defense against a holder who is not that a third person has a claim to the instrument unless the third person asserted a valid claim to the instrument J or W the payee the holder acquired the instrument, or an endorsee, or participated in by theft or forged the signature the theft or the forgery. Of Article 29, protected holder means the holder of an instrument which was complete when he took it or which was incomplete within the meaning of paragraph 1 of Article 12 and was completed in accordance with authority given, provided that when he became a holder, B was without knowledge of a defense against liability on the instrument referred to in paragraphs I and of Article 28, 13. He was without knowledge of a valid claim to the instrument of any person. He was without knowledge of the fact that it had been dishonored by non-acceptance or by non-payment j. The time liat provided by Article 55 for presentment of that instrument for payment had not expired. Fraud or he did not obtain the theft concerning it. Instrument by fraud or theft or participate in Article 30. 1. A party may not set up against a protected holder any defense except Defenses under Paragraph 1 of Article 33, Article 34, Paragraph 1 of Article 35, Paragraph 3 of Article 36, Paragraph 1 of Article 53, Paragraph 1 of Article 57, Paragraph 1 of Article 63 and Article 84 of this Convention. Defenses based on Theon lying atrana aid action between himself and such holder or arising from any fraudulent act on the part of such holder in obtaining the signature on the instrument of that party. C. Defenses based on his incapacity to incur liability on the instrument or on the fact that he signed without knowledge that his signature made him a party to the instrument, provided that his lack of knowledge was not due to his negligence and provided that he was fraudulently induced to sign. 2. Claim to from the raised. The rights to an instrument of a protected holder are not subject to any the instrument on the part of any person, except a valid claim arising underlying transaction between himself and the person by whom the claim is. Article 31. 1. The transfer of an instrument by a protected holder vests in any subsequent holder the rights to and on the instrument w-ic the protected holder had. 2. Those rights are not vested in a subsequent holder if, less than al he participated in a transaction which gives rise to a claim to, or a defense against liability on, the instrument. B. He has previously been a holder, but not a protected holder. 14. Article 32. Every holder is presumed to be a protected holder unless the contrary is proved. Section 2. Liabilities of the parties. A. General provisions. Article 33. 1. Subject to the provisions of Articles 34 and 36, a person is not liable on an instrument unless he owns it. 2. A. If he a person who had signed it signs an ent in his own name, in a name which is not his own is liable. Article 34. A forged signature on an instrument does not impose any liability on the person whose signature was forged. However, if he consents to be bound by the forged signature or represents that it is his own, he is liable as if he had signed the instrument himself. Article 35. 1. If an instrument is materially altered, terms, a party who signs it of the altered text J after the material alteration is liable according to B. A party who signs it before the material alter it on is liable according to the terms of the original text. However, if a party makes, authorizes or assents to a material alteration, he is liable according to the terms of the altered text. 2. Material. A signature is presumed to have been placed on the instrument after the alteration unless the contrary is proved. 3. Any alteration is material which modifies the written undertaking on the instrument of any party in any respect. 15. Article 36. 1. An instrument may be signed by an agent. 2. The signature of an agent placed by him on an nt with the authority of his principal and showing on the instrument that he i.e. sign 1 nanogram in a representative capacity for that named principal, or the anature of principal placed on the instrument by an agent with his authority, imposes liability on the principal and not on the agent. 3. A signature placed on an instrument by a person as agent but who lacks authority to sign or exceeds his authority, or by an agent who has authority to sign but who does not show on the instrument that he is signing in a reaper ntative capacity for named person, or who shows on the nt that he is 81 gnlng in a representative capacity but does not name the person wo he represents, impose liability on the person signing and not on the person vha. He purported to reaper ent.